Good evening, this is John Milburn, Laws 11057 Introduction to Law. It's week number 9, and this week we're dealing with a few issues. It's the formal commencement of legal research that covers chapters 1 and 2 of your text, and also chapter 4. We'd ask you to revisit chapter 6 of your text, but hopefully if you're doing the right thing, you would have been reading in advance. Tonight is a special thing. I also want to speak about brainstorming, provide some feedback in relation to the 2 assessment items so far, and provide some basic hints on what I like to see so that from a documentation point of view, as you move forward, you're presenting something in a form which will be acceptable and something you can be proud of. So it is also feedback week. Thanks very much for those of you who have already had your say, and the Have Your Say button you'll see on the top left-hand side of the Moodle site. So please click on that. It's very important for the university. It's very important for me that you provide your feedback, and I encourage you to do so. You have an opportunity anonymously to let us know what you think of the course, how you find the format, the materials, the assessment. So a whole range of things that you can comment upon. And also I've posted a link on uCrew, and feel free to add some comments there in open forum. But when you have your say by using the red button, it is anonymous. All right, let's talk about presentation of papers. I'm going to share the screen shortly, and I'm going to call up I will call up my sample document. I've referred to this previously. I trust that most of you have already had a look at this, and if you haven't, I encourage you to do so. So I'm just sharing the screen now. I want to just show you a few things. You should hopefully see that screen now. Does everyone see my sample document? If you just give me the thumbs up. Yep. All right. Look, there's no great magic in this, but there are a few basics that people are not seeing. The reason I'm stressing this is I want to ensure that when you move into second year, I can be proud of your work, you can be proud of your work, and you are presenting something which is in an acceptable professional form. If you're charging $400 an hour, you need to create something which is worthy of that type of hourly rate. It needs to be something which is consistent, and it is important to gain the trust and confidence of the person that you are presenting your document to from the outset, usually, especially I suppose if that's your client. So the sample document. Many of you, and I find this very surprising, are not using the styles which are built into the Word program. It's really simple. So assuming that most of you are using Word, you'll be familiar with this type of layout. I think this is Word. I think this is the most up-to-date Word sample, but they're all pretty much the same. All right, so sample document, just highlight that and you'll see that it's the title. And if you want to change that into a different style, you just go along and say that's what you want. Okay, if you want normal, that's the usual font, if you like. So you can see there that it's changed to normal, and that's just the standard typing. Subheading is a subtitle, and back here we have title. So it's really very simple. And you can create that, you can modify that to your taste. So if you don't like the look of that title, right-click, modify, go in, and change it. If you want to change the font size, make it a bit bigger. If you'd like to put it in bold and italics, if you want to change the paragraph layout, then you can do that, change the spacing, etc. So doing all that, you'll come up with a different style of sample. Then if you want to use that sample again, a couple of ways to do it. You can just click on title and it will adopt that sample. Or you can use this, and I think this is a really good little thing to use, this format paintbrush. If you double click on that, it will capture what you have there and it will replace it with something else. So I'll just do that again. So if, for example, you want to copy the subtitle formatting, double click on format paintbrush, go to where you want to adopt the new format and click on it. Then just go back to click to get the paintbrush finished. I'm probably saying things that most of you know already, but it is important. I'll just undo some of these things that make the document look a little untidy. Okay, I prefer double spacing between sentences. That's purely personal taste, but you'll see there's two there. It means that the document's a bit easier to read. Some of you aren't paginating. Paginated simply means put in the number of the page. In this instance, I've done it through the header. You can see that the headers there. You can change your headers, of course, very simply, or you can change the footers, or a bit of both. So if you don't like the look of that, just change the header, then close it. All right, but do paginate. So if you go with a header that doesn't have page numbering, then just go in and make sure that you insert a, let's see, where are we? Sorry, page layout, no, design. Where are these headers? Where do they go? Header or footer, and maybe adopt one that has a page number. Right, so just close that. I'm sorry, this is all probably very basic for some of you, but I was surprised that many of you didn't adopt this type of regime. When it comes to design, you can adopt different designs. There's many built into the Word program, so you can just scan across, and if you like the look of something else, then adopt that. I haven't got a cover page on this. Many of you do, and when you do, it's really well done. Okay, I'll just backtrack on some of those things that I've done, get back to where we started. All right, so you can see how easy that is to do. When you're typing legislation and case law, please do so in italics. You'll see here the name of a case, and you'll see that it is in italics. Very simple. Don't type the year of the case and the citation. You'll see it down here. Hopefully you can follow where my cursor is going. So that's not in italics. If you're typing legislation, that should also be in italics. Okay, so if you're typing Land Title Act, it will be something that you type in italics. So just put that in italics. All right, so any questions so far? Nice and simple? Okay. When referring to the word act in the context of legislation, do capitalise the word. So if you're talking about the Land Title Act, the Act, comma, as it is known, was passed in 2007, full stop. I forget when the Land Title Act was passed, but you'll see that the word act in that context is capitalised. All right, is known, that's passive speech. We don't like passive voice, so I would change that. All right, so did you see what I did there to check that it was in passive voice? I just right-clicked on the blue underlining. Do take note of the blue, green and red underlining. It means that you need to consider something. When you're quoting case, quote the legal citation, so 2007 QSC 34. You don't put in the internet citation like that. All right, so we'll just move on. There are a few other things. Take care with your grammar. If you see the underlining, as I said, please do something about it. Try to avoid legalese. Generally use short sentences. Those of you who've read this sample document would have seen the way I like Lord Denning's wording. And this is great. The customer pays his money and gets a ticket. He cannot refuse it. He cannot get the money back. He may protest to the machine, even swear at it, but it remains unmoved. So that's the sort of thing that you need to think about in terms of your writing. By all means, use flowcharts, use footnotes. When you're citing using footnotes, and some of you apparently don't know how to do this, but I'll just show you. You just go to a Word and reference, insert a footnote. Hopefully you all saw what I said. My preference is that you tab across and then put in your type to reference. You'll see that it's built into the Word program that the font here is smaller. That's 10-point font as opposed to the 11-point font in the body of the document. Okay, all nice and simple so far? I think it's really simple, but again, surprising how many people didn't do that, and it really is important to do so. So that's styles, footnoting, the manner in which you set out your document, some nice easy tips, and also don't cut and paste using different font. I mean, or if you do, just be very careful about it. So just cutting something across into the document, I generally will right-click, and you've got a number of paste options. You can keep the text only. I'll just see if I can copy something now, sorry. You can simply keep the text, or you can merge the formatting or keep the source formatting. And if you keep the source formatting, it may come across in a different type of font. So, and that you'll see there, it's different size font. It's still Calabri, but it's different size. And if you do mix your fonts, it just looks so obvious that you've cut and paste. There's nothing wrong with cutting and pasting necessarily, but you need to make sure that it flows with the rest of the document. So if in doubt, just right-click and match it to bring the text over only. Okay, really simple stuff. Are there any questions from that? Okay, let's move on then. I'll just close this and I'll stop the share. Thank you. Legal research, you would have seen in the commentary that there are a number of ways to do it. We've talked about this before. I guess the most common is the IRAC method, which is where you determine the legal issue, determine the rules, apply those rules, and state the conclusion. So that's covered in the first chapter or two of the textbook, and that's all pretty straightforward. The MIRAT method, M-I-R-A-T, same thing, except that we're adding in the material facts at the start. And that may be difficult unless you know the law, because research may not be a linear process. It may be that you need to think about the who, the what, the where, and the how issues to determine what the material facts are. A rule of thumb is if the answer to the question about who or where or what or how really makes no difference to the overall story, then it's not material. What colour was the car? It was red. Who cares? Therefore, the fact that it was a red car is not material. Was it a car or a train or a boat? It was a boat. Is that important? Yes, it is. So the fact that it's a boat is a material fact. To some degree, it's a judgment call in that regard, but you need to identify that that is the case. So I might just share the screen again so that you can see what I'm working from just on my notes, and that will speed the process for tonight. I'm working through it pretty quickly because some of this material should be, by now, pretty basic. As usual, if you have a question, please use the chat facility or simply come in live. So you'll see there's the MIRAT method. We need to identify the legal issues. Is this criminal law or civil law? Sometimes it will be both. And don't put the blinkers on too quickly, because you may have an issue which is both criminal and civil. It may be an employment issue where there's a breach of contract. It might also be criminal in that there's an allegation of someone stealing from the employer. Identify similarities between the problem and a legal rule. Identify the key terms. And of course, always be mindful of the fact that the issue at hand may be state, or it may be federal, or it may be both. And it is a trap for young players to ignore the possible application of federal law, for example, the consumer law, and certain corporations' legislations or legislation or laws relating to the Australian consumer law, as I said. We need to identify and interpret the rules, and that may be legislation or case law. We call that the primary sources, and my preference is that we always look to the legislation first. Then we look to the case law, then we look to the secondary materials. Many of you in your assignments wrote about the tertiary or the tertiary, secondary materials, citing materials from textbooks, where my preference would have been for you to cite material from legislation first up. Apply the rules to the facts. We talked about reasoning by analogy, inductive reasoning and deductive reasoning. So that comes into play here when we're applying to the law, applying the rules to the facts. So reasoning by analogy means that we're looking for similarities, and when we're talking about similarities in terms of applying the rules to the facts, we're really considering how precedent cases may have a bearing on the way in which you decide the law in a particular instance. Inductive reasoning is broadening, where you're looking at a specific principle to form a general conclusion, and deductive reasoning is the opposite, where you're bringing a general principle back towards a specific conclusion. So those rules in relation to legal logic may come into play when you're trying to apply the rules to the facts. And then, of course, in the Myrat method, we are looking to arrive at a logical and supportable conclusion. Clarifying the legal issues, that's the second step in Myrat, the legal issues here. Just expanding on that, the example used in the Practical Guide to Legal Research is a family law issue involving child abduction. So what you do there is you start in a general way and work towards becoming more specific. Some ways that you can start your general research: a legal dictionary, legal encyclopedias, Halsbury's, which is LexisNexis, or Laws of Australia, which is Thomson Reuters. Just on that point, I'm just going to ask, I'm just going to stop the share facility for a sec, and I'm going to go to gallery view. So if you're a bit shy, you can mute your camera. But I'm just going to ask, is show of hands will be fine, or you can come in with a chat facility. Are you using the legal research facilities on the CQU Law Library? And you don't worry, you can be honest. If you're not using it, tell me. So hands up if you are. Yes, we're getting a few. We're getting, I'm in love with Halsbury's, can't do without it. Yes, yes, that's good. That's great. It costs a lot of money. Believe me, to get these resources in private practice, you will think, you might take it for granted now, but it's wonderful. Halsbury's is getting a lot of votes. Okay, agree with you, Rowan, says Letitia. Thank you very much. All right, and if you're not using it, I won't get you to put your hands up, but please do so. It's important and it's valuable. Okay, any questions? All right.
Sorry, John, I don't have a question, but I've got a quick little tip. If people aren't studying Contracts A this semester, our lecturer for Contracts A, Anthony, actually did a really good walkthrough in one of our Zoom sessions for Halsbury's. That's on YouTube. So it might be worth looking that up and figuring out how to work Halsbury's, because it's very helpful. Yes, Anthony's very good at what he does, so that would be an excellent session. Thank you very much for that, Kimberly. Okay. All right, let's just go back to what we're discussing in terms of tonight's content. So again, if I'm just sharing that screen, you should now see my notes. And clarifying the legal issues, yep, Halsbury's, for example, doing your effective research. Now, here's where in practice you need to work quickly but thoroughly. And there is that eternal pressure between the work that you need to do and the billing pressure to do it within a timely fashion. So you might need to think laterally and use double quotation marks around a phrase. I actually prefer single quotation marks, but I'll go with what the text says to do. In terms of thinking laterally, coming back to that point, tonight we'll be doing a brainstorming exercise, and the idea is to start you thinking about practicing law in the wider context in circumstances where it is not necessarily obvious to you where you should start looking, or what the discipline of law is that under consideration. Online law, chapter 2 of your text, have a look at Ostley, the note up function. I trust we all know the note up function, don't we? You can just nod if yes, that's a yes. All right. I love the note up function. And remember, it can be used in reverse.
Note up can be used when you're in legislation and you're looking for relevant case law. It can also be used when you're in case law looking for relevant legislation. And the Boolean search facility, it's table 2.1 of your text. Do have a look at that. Researching legislative material, that's chapter 2 of the guide. Generally, the first place to commence your legal research is to refer to the legislation. You've heard me say that plenty of times. The authorised sites are ComLaw and the Office of Queensland Parliamentary Council. I do actually prefer Austlii. I find it more user-friendly, but it's not authorised. Kelly Stidiford is no longer our law librarian, it's Joe Keogh. But what you can do, if you have a question in relation to the law library generally, ask through TASAC, T-A-S-A-C, rather than go directly to the law librarian. Now, in the second assessment piece, you were required to make comment in relation to the date of commencement of legislation. And sometimes it's pretty obvious when the assent is going to, the date of assent, proclamation and commencement date, but sometimes you need to consider the Acts Interpretation Act. So at a Queensland level, I think we talked about this before, it provides at section 15A that the effective date of the Act, that should be capitalised, is the date of assent. To determine the date of assent, go to the Office of Queensland Parliamentary Council website. I'm not too happy with that, so I'll just change it, cap that, and have a look at acts as passed. Okay, I think that's better capitalised as well. All right, and so the section 15A of the Acts Interpretation Act provides the date of that the Act commences on the date of assent, except so far as the Act is otherwise expressly provided. And I'm sorry to do some tidying up as we go, but in a sense I'm also trying to demonstrate what I do on Dragon. In terms of Commonwealth, have a look at again the Acts Interpretation Act, section 3A2, the effective date 28 days after the date of assent. All right, so we've talked about this before, the need to consider the possible application of the Acts Interpretation Act at both state and federal legislation is well worth considering. Any questions so far, or we're right? Right, researching case law, the authorised materials we've talked about, the unauthorised reports. In practice is not a great deal of concern now because the material really is essentially authorised. Bench books, very valuable. I think we did talk about bench books last week, didn't we? Yes? All right, so I described it as a little insight into the mind of a judge in that you can get to see what a judge is likely to say. Practice directions are also very useful and necessary to understand that practice directions can often be the first place you need to look. So if, for example, you wish to apply for probate, then have a look at various practice directions. It will give you some idea of the practicalities involved. Okay, so bench books we talked about, and now we'll go on and start talking about brainstorming in a more general sense. No questions so far? I'm doing a lot of talking, I'm moving pretty quickly. And I want to talk about holistic advice. I'm going to stop that share for the moment. And what I think is important is that you understand in practicing law that it's not necessarily a clinical exercise. I guess in simple terms, your objective is to do the best that you can for your client to obtain the best possible outcome. Sometimes that means providing some advice which isn't necessarily going to be strictly legal. You might find that odd, but bear in mind, alternative dispute resolution is an area of practice which has grown dramatically over the past 30 or 40 years, and it is now a situation where broad thinking is encouraged rather than discouraged. So think about different options to litigation. And when you first see a client in the context of a dispute, think of it initially perhaps as a form of legal triage. You're there to make some initial comments, make some initial, or provide some general options, and work towards what is tailored for the client's best interest. Think about the cost associated with litigation and think about some of the low-cost alternatives that should be considered by the client immediately. Sometimes clients come in hell-bent on litigating. They're determined to fight no matter what the cost. Take care if you hear the words, I'm not going to settle this or compromise in any way. I want to fight because of the principle. If you hear someone wanting to advance because of the principle, you've really got to double check with them and ascertain why they are so determined to fight for the principle. Is the client acting upon emotion or logic? Is an important thing to ask yourself at that early legal triage, as I've described at stage. You also need to cater for the personal circumstances of the individual. Think about the individual's intellectual abilities, perhaps age, cultural factors, risk perspectives might come into it as well, and the socio-economic issues also. So there are a number of things that you need to consider at that early stage. Also, there is the question of capacity. Do you have a client who is perfectly capable of making decisions and is capable of providing detailed and appropriate instructions? Or do you have a client with a borderline intellectual disability, perhaps a circumstance where the client has just received a very substantial compensation payment? Do you, and that client wants to do something that's a bit silly in terms of some potential litigation or perhaps gifting things away, or maybe the subject of some form of undue influence, then in those circumstances, you need to bear in mind that your client may need to be protected, and that might be an issue for QCAT for guardianship. I think I did show you from the Queensland Law Society website last week the excellent publication in relation to legal capacity. And have you had a chance to look at that? Has everyone had a look at that issue of legal capacity and the Law Society generally? If you haven't, I encourage you to do so. So please consider that. All right. You are an advisor there to consider both legal and non-legal options for a client. We'll be talking about that in a more practical sense this evening. And you need to tailor your response to the particular question. It might be generic, or it might be that you need to consider the individual needs of the client. So what are some of the other things to think about at that first stage when you're dealing with a client? Sometimes you need to think about providing legal information and education. Maybe your client simply doesn't understand at a basic level what is involved in a certain matter. I mean, for example, in a conveyancing situation, if a client comes to you asking for advice in relation to a purchase of a house, thinking it's a very straightforward matter, in a way you need to educate your client to understand that this is not like buying a loaf of bread, that it's not just a simple matter of seeing a house and asking for that house to be transferred into your name in exchange for money. There's a lot more to that. There are a lot of issues that may arise. There are legal and practical and economic issues that need to be taken into account. It's far more complex. It's also far riskier. So if you're acting for a client who's putting down, say, a 10% deposit, you need to take them through the clauses in the contract very carefully. So that's what I mean by, in certain circumstances, your obligation to provide legal information and education to a considerable degree. If you're dealing with a litigation issue, you need to understand the basics, of course. Where did the dispute arise? Who is it against? When did the dispute arise as well? So those where, who, when, why, how type questions are really very important. Our legal insurer Lexon provides a very good instruction sheet so that you can take your instructions and you're prompted to ask some of these things. I mean, where the dispute arises in a litigation context may be important because it may be that you shouldn't be litigating in Queensland at all. Perhaps the contract was in fact created in New South Wales. And by not asking that simple question, where did the dispute arise, you may end up costing your client, and therefore perhaps yourself, tens of thousands of dollars in wasted legal fees by simply going to litigate in the wrong state. Who is the dispute against? You might think that your dispute is against Joe the builder, but in fact the dispute may be against the company which is owned by Joe the builder, but is nevertheless the appropriate legal entity. So if you issue proceedings against Joe the builder and you don't realise that you should have initiated proceedings against Joe the builder Pty Ltd, then by the time you realise what you should have done, it might be too late. The action may be statute barred, and then you've got an indemnity claim. And it's no good thinking, oh my gosh, I should have asked that simple question, who, at that first interview, but I forgot. When did the dispute arise? Why would that be important? Why is it possibly important to consider when the dispute arose? Can anyone come in with a chat facility? What are we concerned about there? When legislation applies, yes, it may be different legislation that applies. Statute of limitations, yes. They're excellent answers. Thank you. Statute of legislation. What legislation are we talking about? So legislation does change. The law that was applicable at a certain time may not apply now, but the really important issue there is the statute of limitations. So when did the dispute arise? Sometimes it's not so obvious. Client comes to you and says, look, to help my daughter, I lent her $300,000 so that she could buy a home. She's now going through a separation. It's really sad. But what I want to do is ensure that my money is protected. So as much as I hate to do it, I need you to send a letter of demand to my daughter and if need be, sue to get that money back. Why should it be important to ask when that dispute arose? Can anyone tell me? We know the amount, we know the other party, we've got the who, we've got the what. Why is the when important? Again, come back to statute of limitations. Before or after marriage, says Rowan. Yes, there may be an issue of was the money paid prior to marriage? It now may be that there's an argument about the husband coming in and taking some of that money. There may be arguments also about whether it was a loan or a gift. But where you have, for example, a loan repayable on demand, it may be that by the time you make the demand, it's too late. You might be statute barred. So there are some grey areas there that you need to consider. So always think about that: where, who, when, what, how. Then when you're giving the advice to the client, think about self-remedies that may be available. Maybe you think about specialists. Do you need to engage specialists? Do you need specialist non-legal services that should be made available to the client, or at least considered by the client? Do you consider early intervention strategies? Do you need to consider ethical obligations? So this is one of the preliminary issues. A client comes to you and says, look, I want to engage you privately. I'm prepared to pay you substantially. I've got all this money. If the client is otherwise eligible for legal aid, is there an ethical issue in not doing the job on legal aid when you are offered the money? The answer there is, generally speaking, if they've got the money, they won't get legal aid anyway. So that probably is easy. But the point of the exercise is to ask yourself that preliminary legal ethical issue as well. So you need to consider legal and non-legal services in many different ways. You need to consider the risks to you and to the client from the outset. You need to consider which organisation is appropriate for dealing with a particular dispute. Okay, I've been doing lots of talking. Now we'll hand it over to you. What I'm keen for you to do is consider the exercise that I put forward on Moodle. I'll just go to gallery view now, and you can come in and make any comments either by the chat facility or by simply unmuting, coming in live. Okay, so here we go. I've done all the talking about the things that you might want to consider at triage, but here what we're doing is this. You are now working in a law firm. You're required to provide instructions to a client faced with a legal problem, a consumer issue or debt issue. It's the sort of thing that you might get in first year. So we want to know all the possible options, the risks and the rewards about the issue at hand. Okay, so the particular circumstance is this. You're acting for a client who is, let's say, the daughter of a person from whom she bought a car. So you're acting for a daughter. Mum sold her the car. The car is now playing up, and she wants some advice on how to go about getting some solution. Tell me, what sort of options will you come up with now at that first interview? Legal, non-legal, practical, fire away. So it's really a brainstorming option. You're acting for the daughter. She's got a car. The car's no good, and mum sold that car to her. Are there some legal options that are available? Think about some legal options. Okay, so we've got any documentation to prove ownership on the sale. Yes, so documentation. Family's a difficult one. Best to say, oh, the car just broke. You want to be careful not to sabotage the relationship. That's important as well. Ask the daughter actually what she wants as an outcome. I really like that. Check what the client actually wants. Was the car checked before? So what we've been dealing with is some issues. Ask the daughter what she actually wants is an issue to do with what is the outcome that you want to achieve. Was the car checked before? That goes to the facts. It also goes to expert. Were the discussions that she had with the mother to request a remedy? So there might be issues about the evidence. What were the discussions beforehand? Are there discussions now with mum to request a remedy? Do we need to go to a legal situation? Are there different alternatives available? So if we weren't going to go to a court, where else could we go as a potential remedy? Just think out aloud. QCAT, mediation, yes, I like all these. NCAT, yep. So these are the civil and administrative tribunals. Ask what outcome do you want? Yep. Are there any other issues? Okay, so there might be. Now tell me from a factual point of view, if you went to go to court and you wanted to prove your case, what do you think you'll need to establish your case to the satisfaction of the court? Now I'm talking about the evidence. What evidence do we need? Okay, information about what price you bought it for. Is the consideration reasonable? Yes. How would you find out if it's reasonable? Proof of purchase. Is there a contract? Do you have a quote from a repairer? So we're now talking about the evidence at the time of the acquisition. We're talking about the evidence which might be in writing, might be verbal. We're talking about expert evidence from a repairer. How long ago was the car bought? Excellent. I'm glad that somebody asked that question because we talked about the who, where, what, how, when questions. So it's important. It might be statute barred. There might be some issues there as well. So how long ago was the car bought? Objective test we have in mind as well. So the purpose of the exercise is how did the damage occur? Yep. So the purpose of the exercise is to think at that initial stage about all the different things that may come into place, not only just now, but down the track, and think about the different options. Do we send this client to mediation? Do we send this client to some form of ombudsman? Do we invite the client just to simply go back and talk to mum, have a cup of tea with mum, see and sort it out? Are there different types of alternative ways to resolve the issue? For example, do we encourage both parties to have a lawyer and we have a round table, 2 lawyers, 2 clients. Do we send the parties off to Relationships Australia? Do we involve the third party who might be a family member who can help to resolve this issue? Do we try to make contact with mum and set up some sort of mechanism which will allow this to be resolved without going to litigation? For example, it might be an agreement. Look, how about we go to this repair shop and whatever that expert says will go. So lots of different ways to potentially resolve that issue. So in terms of the overall advice to the client, it might be, after you speak to them in general terms, the cost, the risk, the family relationships, you might say, look, I understand that the amount of money is substantial. There are issues of concern, but you might want to consider simply walking away from the dispute to maintain family harmony. I'm not necessarily recommending that to you, but it is one alternative. Another thing, you might say, well, how about you make a direct approach? Keep me out of it for a while. Don't get the lawyers involved. It's never easy to resolve disputes of this nature with family, but perhaps if you simply make arrangements to have a cup of tea with mum, maybe have a beer or a glass of wine, you might be able to sort it out. Taking that one step further, you might say, well, how about we organise a mediation? It's a family arrangement. We don't want this to become litigious. There are excellent community-based mediation centres, and one of the mediators might be able to assist in not only dealing with the problem, but also perhaps dealing with some underlying issues that now have arisen between you and mum, and maybe explain that process. There are some free processes through the alternative dispute resolution centres, which are community-based. It may be that Office of Fair Trading could get involved, or there might be ombudsmen that may be able to assist. So there are a number of different options. You then might think about the litigation scheme or stream. You're thinking about the evidence. Maybe get a statement from your client. See if there's any recording of some of the evidence in one way or the other. Might be an oral recording, or it might be in writing as well. And then you go up to the next level of litigation, sending a letter of demand, etc. So there's a whole range of different things that you could consider doing at that stage. All right, so we'll do something a bit similar next week, but it is important that you understand this is all examinable, and I might want you to explore in the exam different options that could be available to you in different circumstances. Are there any questions before we finish for this evening? You've all been very good in providing lots of answers. Okay, thank you for that. All right, well, we might stop the recording now, and we'll see you next week.